There, perhaps just briefly on the position in Nigeria.
Thank you very much. So I'm also from a jurisdiction that has contributed very generously to the jurisprudence globally. Nigeria's, I like Aisha's comparison with on paper and on the ground. What I tend to see from Nigeria is that from a policy perspective, it is extremely arbitration friendly. From an implementation perspective, that's where you start to see the nuances. And even the 2024 SOAS Arbitration in Africa Survey report shows that. So Aisha, when you gave the statistics, you showed that Layla. Yes, Layla, Aisha's on my side. Layla's against us today. But the survey shows that 34% of respondents had a perfectly fine experience in Nigeria and in Kenya. So what that's telling me, it's depending on certain circumstances will determine certain outcomes. Now, from a policy perspective, we have gone from a transition from the Arbitration Conciliation Act, which was modeled on the 1988 version of the ancestral model law, to the Arbitration Mediation Act, which cured some of these difficulties, if I can call it that we were experiencing on ground within the jurisdiction. And if time allows, of course, I'd be happy to speak to some of those problems. And likewise, from the judiciary, we had, for instance, in 2017, practice directions from the then Chief Justice on how courts should treat court actions that also had arbitration clauses. And essentially what the direction said was that not only should you decline jurisdiction, but award damages against the party that has commenced court action in breach of the arbitration clause. Now, that went even further than what the Arbitration and Conciliation Act required. It was almost akin to the position under French law, where you are obliged to decline jurisdiction unless the arbitration agreement is manifestly void. Under the ACA, as it then was, there was a limited scope of review, under Section 4 at least, to determine whether the arbitration agreement was null, void, inoperable, or incapable of being performed. What the Supreme Court was saying was that they don't even perform that analysis. Decline jurisdiction once you're satisfied that an arbitration clause exists. Now, the implementation of it has been problematic in the sense that the decisions that have contributed so generously to the discourse is the one that gains a lot of the attention, not only within Nigeria, but internationally. Bad news travels extremely far. So we see decisions, for instance, that are at odds with the policy, with the arbitration-friendly policy. We see Supreme Court decisions that, on the one hand, say that the courts will not interfere where there is an arbitration agreement. And on the other hand, you see high courts granting anti-arbitration injunctions to stop an arbitration from proceeding. So it's very much a topsy-turvy situation. And I think that's fueled by the fact that Nigeria is a federal system. So you have federal courts and various state courts. And in the commercial jurisdictions like Lagos, Port Harcourt, to a lesser degree, Abuja, you see some of the very good decisions coming out. Whereas in the not so commercially inclined jurisdictions where the judges may not be as familiar with the principles of arbitration, you find that parties will go, particularly if they want to deploy the black arts, as I call them. They will go to these jurisdictions and they will try their luck. And invariably they will get decisions that are not favoring the arbitration system as a whole. Now, with that said, the conversation there is a general recognition that this is a problem. And the conversation has gone to, well, how do we ensure a uniform application irrespective of the state you are in? So, for instance, there is a conversation with the National Judicial Institute, which is the body responsible for training judicial staff and administrative staff attached to the various courts on arbitration and arbitration-related matters. So we are trying to see how we can get arbitration on the annual curriculum for newly appointed judges, and also for the refresher courses for existing judges.